to start with arguments in case number 29257, State of Ohio versus James Bressi. Each party will have 15 minutes to present their arguments. If you haven't argued here in a while, we do have the clock up on the wall now, so that'll help you keep track of your time. Let me know if you're going to reserve any time. Appellant, you could reserve up to 5 minutes, of course. We've read the briefs and are ready to proceed if you are.
Thank you, Ryan. Good morning, and may it please the court. I'm Jacqueline at Corrigan on behalf of the state of Ohio, the appellant in this case, and I would like to reserve 5 minutes of my time for rebuttal. Again, this is the state's appeal of the trial court's decision in this case to grant Mr. Bressi a new trial. The state contends that this was an abuse of discretion for a combination of at least 3 reasons. The trial court firstly abused its discretion when it relied on inadmissible testimony by receiver Mr. Berkins. The trial court also did not require Mr. Bressi to demonstrate all of the factors that he needed to demonstrate, that was his burden to demonstrate under State versus Petro to obtain a new trial. And as to other factors of Petro, the court reached unreasonable or arbitrary conclusions. In addition, the trial court did not engage in a kind of circumspection that this court said in State versus Jalowick that it must engage in before granting a new trial under Criminal 3386. So regarding the inadmissible testimony first, the testimony of Mr. Berkins was inadmissible for 2 reasons, essentially. First of all, it was hearsay without an exception, and even hearsay within hearsay in many circumstances. Mr. Berkins was testifying as to emails that he had reviewed, and a second reason, never introduced those emails for the court to even see. So it was unreasonable for this court to approve a new trial based on emails that had been sight unseen. So it was Mr. Bressi's burden to produce those emails to demonstrate what Mr. Berkins was testifying to under State versus Williams and State versus Holmes, and never did. So this, by permitting that testimony, the trial court ignored precedent and the law, because hearsay and unverified documents do not satisfy a new trial movement's burden under Holmes, and the evidence rules do apply in proceedings for a new trial under Criminal 3386. And for authority for that, that's again State versus Holmes, State versus Scheibel from the Ohio Supreme Court, and other cases that are cited in the state's brief. So because this court ignored the facts and circumstances of the controlling precedent, ignored that this was hearsay, basically in the trial court's ruling actually belayed the question of whether this evidence was even admissible, the trial court issued an arbitrary and unreasonable decision. As to the 6 prongs of Petro, anytime that a claimant is saying that there is new evidence that should grant them a new trial, they have the burden to demonstrate all 6 prongs that are listed in Petro. First of all, the evidence has to disclose a strong possibility that there will be a different result if it's presented at trial. So that evidence has to destroy the state's key witness, has to exonerate the defendant, or make it clear that no reasonable jury could possibly convict the defendant, and that's pursuant to this court's determination in Jalowick. It doesn't meet that burden to say that the testimony would lessen the weight of this state's witness's testimony, and that's what the trial court said in this case, and that flies in the face of Jalowick at paragraphs 41 through 45. Diminishing the weight of the evidence is not sufficient. It has to actually destroy the person's testimony. Secondly, the evidence has to be discovered after the trial has been completed. In this case, one of the affidavits that Mr. Bressi presented was by a lady whose last name is Seifert. Her testimony was not discovered after trial. Ms. Seifert actually was listed on Mr. Bressi's witness list prior to trial. And on that basis, during the hearing for the new trial motion, the trial court actually states on the record that there was, and I quote, no construction of the law, end quote, that would allow it to consider Ms. Seifert's affidavit. And yet the court did anyway, and relied on Ms. Seifert's affidavit in the decision granting the new trial. So by basing its decision, at least in part, on testimony that the trial court had already said that there was no construction of the law that would allow her to consider it, that in itself was unreasonable, arbitrary, and unconscionable. In other words, it was an abuse of discretion right there. But as to the third prong of Petro, the evidence has to be such that it could not have been discovered with the exercise of due diligence prior to trial. The court didn't actually consider this when it made its ruling, but all of the evidence concerning the actual one victim for whom we have a conviction, all of that was in Mr. Bressi's files. All of the other patient files were also in his possession. And indeed, Dr. Bressi testified during trial that he found evidence of the alleged conspiracy against him that is the crux of, well, it was the crux of his defense at trial, and it's the crux of his new trial motion. He found some evidence of that alleged conspiracy in his patient files that he was reviewing prior to trial and in civil suits that had been filed against the practice already. So that was evidence that with due diligence could have been presented at trial. And again, like I said, the trial court did not consider that in the ruling that was made. In the fourth factor, the evidence has to be material to the issues at trial. Now, the trial court didn't consider that factor either, and I would remind the court, this court, of what the actual issue was concerning CH, who was, again, the only victim for whom there was a conviction. The issue was not whether Dr. Bressi's partners wanted to oust him from the practice. The issue was not whether they asked CH to lie or to embellish her testimony. The issue was, did Dr. Bressi commit a sexual battery against her? So that was the actual issue, and the trial court didn't discuss that. As to the fifth factor, and I hope I'm not boring the court with the recitation of all these factors, but with the fifth factor, that wasn't really considered by the court either. The fifth factor is that the new evidence has to be not merely cumulative of evidence that was presented at trial, and that's pursuant to this court's decision in State v. Prade. Making a stronger case for Dr. Bressi's contention that there was a conspiracy against him, that's cumulative. That's the essence of cumulative evidence, because that's the same theory that he presented in his defense at trial. So strengthening that case is cumulative, not new. And finally, the evidence has to be not merely impeaching or contradicting of evidence that was presented at trial. The trial court's decision in this case relies on the evidence, the new evidence, being impeaching. The court actually put in the decision, or the court's whole theory in this decision was that the impeachment potential of the new evidence changed the landscape of the evidence. And that was the whole crux of it. So,
Well, the court indicated that it was aware of the rule that it should not grant a new trial based on new evidence that only impeaches and contradicts. And then went on and discussed why she felt the new evidence doesn't more than impeach or contradict. So it seems like the court did consider that and apply that.
The court did consider and apply it, but the state's contention is that in considering it and applying it, the court actually reached an unreasonable and arbitrary conclusion. Because when the court was saying that this, hinging the decision to grant a new trial on the fact that the court thought that the new evidence revealed credibility issues for CH.
Well, I think
might
you said
lessen.
it created a different version of the events that the jury didn't have an opportunity to consider.
But Your Honor, the different version of events isn't actually a different version of the events concerning whether Dr. Bressi actually committed a sexual battery against CH. It gets to CH's credibility, not whether there was an actual sexual battery against her. And I would remind the court that during his testimony, Dr. Bressi did admit that he had engaged in a touching of CH and posited that she had misinterpreted. So it was a matter of, did she misinterpret it, or was she actually the victim of a sexual battery? The jury found that she had been. And I would also mention to the court that in the record from the original trial, there is a jury question that was issued to the court, and CH's testimony and CH's part of the question wasn't a question that the jury was concerned about. They were concerned about the credibility or the believability of other witnesses instead.
Thank you for that answer. You're down to 4 minutes for your rebuttal, 4:06. You want to
Thank
keep
you.
going, you can, but I want to.
I shall reserve those 4 minutes, thank you.
All right, thank you. And counsel, you'll have 15 minutes.
Unreasonable, arbitrary, unconscionable. That's why we're here today, Your Honors. Unreasonable, arbitrary, unconscionable. I'm Mike Callahan. I'm here on behalf of James Bressi. Good morning, Your Honors. We're here about whether or not the trial court abused its discretion. I submit to you respectfully that this hearing today is not about whether you agree with the trial court's decision. It's not about whether you like it. It's not about whether you'd have done the same thing. It's about whether the trial court acted in a manner in reaching that decision that was unreasonable, arbitrary, or unconscionable. I found it interesting as I prepared for this. If you look up the Webster's Dictionary definition of those words, when you get to arbitrary and you get to unconscionable, they both refer to unreasonable. It is as if they are very much the same thing. I would submit to you that one of the ways to determine whether a trial court acts in that manner is to view how they approach this. Certainly, the trial court required the defense to follow Criminal Rule 33 to a T. We had to follow and file the motion for leave to have a new trial heard. That was done. The state filed a motion in opposition, a hearing was held on it, a decision was made, and it was granted by the court after having an opportunity to look over everything and see the affidavits. Next comes the actual motion itself. The court granted the motion for the defense to file its motion for a new trial. It was filed. There was supporting documentation for it. I will certainly concede that it wasn't until in the middle of that that the testimony of the court's receiver, Mr. Berkins, came forward, and that's why Mr. Berkins was called as a witness to testify in court, and the court certainly accepted that. I submit to you that when you look at how the court followed all the rules, or the rule of Criminal Rule 33, you'll see that the court did not act arbitrary in the least bit. That the court's decision was well thought out, and it was following the law. What about the court's reasoning? I submit to you that if you look at the trial court's reasoning from page 7 through page 11 on its analysis of the evidence that was put forth of the court's decision, that it sets forth in very succinct forms its reasoning. Talks about the 6 prongs of Petro, how the court has examined them, how the court came to its decision on them, and quite frankly, why the court ruled the way the court ruled. Clearly, the court was mindful of those prongs where it says on page 8, the court's mindful that it should not grant a new trial based upon evidence that only impeaches or contradicts the former evidence. However, the new evidence Bressi seeks to offer does more than impeach or contradict. Rather, it presents a different version of the events. And it goes further on page 9, the new evidence proffered by Bressi represents a substantial change in the underlying facts of the case.
Is there a problem that the court considered Ms. Seifert's affidavit after ruling that it was not going to consider?
Your Honor, this learned panel has been judges for many, many years. It would not be the first time I've seen a court change their mind, make a different decision based upon evidence and testimony that they've heard. Certainly, I would concede to the court that if the trial court had made its decision solely on the affidavit of Seifert, that we might have a problem. It is not that. It is the cumulative effect of cumulative evidence of all the affidavits and the testimony of Berkins that gets us to this point.
Was that ruling a ruling on a motion in limine, or what was the context of the court's statement that it was not going to consider Seifert's evidence?
I think that was just the court speaking out loud. I mean, for lack of a better word, you know, the court was speaking in court during one of the hearings we had on it.
Thank you.
The court clearly and intelligently sets out its reasonings as to how the defendant has satisfied the 6 prongs of Petro. I don't think it's necessary for me to go into it, because this goes back to what I said at the very beginning. This is not about the court's decision. This is not about the court's, whether you agree with the court's decision. This is whether the court acted unreasonable, arbitrary, or unconscionable in making its decision. Now, I feel obligated to speak to the conspiracy because that's something that the court talked about. Clearly, there's new evidence of that. It is not enough that Bressi suspected it during the trial. There's a huge difference between suspecting something is going on and having definitive, unrefutable evidence that it is happening. And that's what we have here. Unrefutable evidence that this conspiracy occurred that was not available at trial, that we didn't know existed at trial, and that we couldn't have gotten with any type of diligent effort that we did set forth to get it. I would also bring to the court's attention in looking at the transcripts, Berkins was not sought out by Bressi or myself. Berkins came forward on his own. Now, one of the things that has been lost throughout this process is that Berkins is a receiver duly appointed by the court. He, in effect, stands in the shoes of the judge that appointed him as an officer of the court. He testified as an officer of the court. And I submit to you that he has a higher standard. It would have been no different than a judge or a lawyer testifying in this particular case. I think that by attacking Berkins, you lose sight of who he is, how he was appointed, and what standard he stands for.
Was this testimony hearsay?
I would submit it was not. However, if it is, the court addresses it that it was hearsay that was admissible. in its decision. I certainly, that, and I would also say that I don't believe that was objected to at the time. I don't think the trial court record would show that. I also want to set the record straight that the state has come here today and in its brief and continually referred to Bressi's conviction as sexual battery. This court is well aware of the fact that sexual battery was not what he was convicted of. It was a sexual imposition, a misdemeanor. I think that it tends to, while I'm certain that this court can look beside that and away from that, it certainly tends to inflame the argument. He was never convicted of sexual battery, convicted of one misdemeanor, sexual imposition. Your Honors, I don't have a lot more to say. I know I still have more time, and I'm not going to waste the court's time. I'm going to leave you with one final, I guess, observation. What we are doing here today is is kind of unusual. Very seldom does defense get in a position where they're the appellee, where they have literally won in the trial court and must come up here and defend. Usually the roles are reversed. And the state is standing here before you arguing things like manifest weight of the evidence, for example, and saying you should not interrupt the decision of the trier of fact because the trier of fact had an opportunity to view and listen to the evidence and make that decision. I submit to you that that's a very good analogy of what's going on here, and I leave you with this court's own words. This court has repeatedly held that the trier of fact is in the best position to determine the credibility of witnesses and evaluate their testimony accordingly. I ask you to apply that same standard here today.
Do you think it was necessary for the court, in its opinion, to address all 6 Petro factors? Do you think it did? Or do you think the court jumped to indicating that there was a strong probability based on a different result based on the circumstances, totality of the circumstances in this case?
I think that the trial court did address them all in its decision, including the way it referred to 2 and 3, because it said it had already ruled on that by granting the motion for the new trial. So I think that they did address them, and I think they addressed it sufficiently. I keep saying they. She did address it sufficiently to satisfy the requirements.
All right.
And lastly, the site that I read to you of your own words, I want to give you the site for that. State versus Bressi, 2016, Ohio, 5211. Thank you.
Thank you for your argument. 4 minutes and 6 seconds left for rebuttal.
Thank you, Your Honor. Judge Chiozza, getting to your question to defense counsel concerning Ms. Seifert and whether the trial court's reliance, even in part, upon her affidavit was a problem. I would remind the court that the trial court did not hear any testimony from Seifert during the hearing, and for the context of that discussion about Ms. Seifert and whether the trial court would consider her affidavit, I would ask the court to look at the transcript of the hearing at page 43. Unfortunately, I don't have that with me right now, or I would read it to the court for brevity's sake, but that's the reference, that's the point at which the reference was made. As to the conspiracy, counsel states that there is a difference between suspecting a conspiracy was occurring and having unrefutable evidence that it had occurred. However, there was nothing in the new evidence that Mr. Bressi brought before the trial court that showed that nothing more than speculation that CH was actually a part of that conspiracy. There was
There was an
information.
email, wasn't
Well, there were emails, according to Berkins, and according to, yes, his hearsay testimony, because the emails were never presented to the trial court. According to Mr. Berkins' hearsay testimony concerning the emails, he said that there were emails between Mr. Gould, who was hired by the practice in 2014, and the remaining partners of the practice about whether they should encourage CH to lie or to embellish her testimony. There's nothing more than speculation as to whether those partners actually approached her or encouraged her to lie or embellish. Instead, there's an affidavit that was presented by the state from CH in which she denied that both things happened, that she was not encouraged to lie about it or embellish her testimony, and that she did not do either. So this is nothing more than speculation. Same thing with the other affiants who actually were not listed on Mr. Bressi's witness list prior to trial. They said that CH called them and she was angry with them because they would not report Mr. Bressi's conduct. That does not actually, it really is, there's no real link between that and a conspiracy on the part of Mr. Bressi's practice partners to oust him from the practice. So that's speculative and just too tenuous. And this court has actually said that speculative accusations such as this have, and I quote, virtually no evidentiary value in the context of Prim Rule 33A6. And that's from Jalowick at paragraph 43. So speculation is not sufficient. But that's what we really have. Now, getting back to Berkins, even the testimony of judges and lawyers when they appear in court still has to conform to the rules of evidence. If I were to go into trial and present the testimony of another attorney, say in a post-conviction relief petition situation, that testimony would still have to conform to the rules of evidence. I would still have to make sure that what that person was testifying to was not hearsay without an exception. And there is not an exception in the hearsay rules for judges, lawyers, or other officers of the court. We don't get a pass. And as far as whether there was an objection to the hearsay, yes, I believe there was in the state's post-hearing brief. I believe that if I'm recalling correctly, the state did object to that hearsay testimony.
And thank you. You used all of your time.
Thank you. All I would leave off with was the state asked you to reverse and so that Mr. Bressi can begin serving his time in jail. Thank you.
Thank you both for your presentations. The court will take the matter under advice and issue a decision in due course. Of course, the court will mail you each copy of the court's decision on the day it's released, and the opinions are posted on the Supreme Court of Ohio's website.